we'll just wait for our audience to join. It's already. Yeah, so we are already live on LinkedIn and YouTube, and we'll wait for our audience to join in a few more seconds. Yeah, so I think we should start. I think people are joining us on LinkedIn. So I think we should get started with the webinar, right? So hello and welcome everyone. I am Gayatri from the Office of International Programs and Events at World Law Alliance. I'm really excited to have you all joining us here for the conference, Cross-Border Enforcement of Arbitral Awards, the Practicalities Beyond New York Convention, a precursor to WLA 2023 Dubai. We are also streaming this live on our LinkedIn and YouTube channels, so you can always access the recordings there as well. And today we are joined by this amazing panel of speakers, Mr. Donny Surtani, Mr. Gabe Bluestone, and Mr. Nicholas Bortman. And I would now like to introduce our esteemed panelists to our global audience who are watching this live on LinkedIn and YouTube and on Zoom. To start with, Mr. Donny Surtani. Mr. Surtani is a barrister, arbitrator, and mediator qualified in England and Ontario. He is the Chartered Institute of Arbitrators and a former accounting and finance professional. He regularly acts for claimants and respondents in international arbitrations and has advised parties on cross-border enforcement issues. Thank you, Mr. Donny, for the great idea and initiative to organize this panel discussion. Next, we have Mr. Gabe Bluestone. Mr. Gabe Bluestone is an investment manager and legal counsel at Omni Bridgeway. Gabe is responsible for sourcing, evaluating, and monitoring award judgment enforcement matters to resolution. He has significant hands-on experience enforcing awards against sovereigns, state-owned entities, corporates, and high net worth individuals. Gabe serves as a resource for clients in managing and executing domestic and cross-border enforcement strategies in multi-jurisdictional asset recovery proceedings. Prior to joining Omni, Gabe was a partner at a boutique litigation firm focusing on judgment and award enforcement. Thank you, Gabe, for believing in us and joining as a speaker in this panel. So lovely to have you here. Moving on to Mr. Nicholas Bortman. He's a co-founder of Radars, a London-based investigations firm specializing in litigation support. His experience includes litigation and commercial and investor state arbitration in UAE, Lebanon, Singapore, Cayman, UK, and US courts and arbitration centers. He has acted for UHNW, corporate, sovereign, and supranational clients and given evidence before multiple arbitral tribunals and in US federal proceedings. He has also consulted for the International Criminal Court of The Hague, evaluating the court's financial investigation practices and advising the Office of Prosecutor on asset recovery in Africa. Thank you, Nicholas, for gracing our audience with your presence. To our audience, if you have any questions during the conference, Send us in the chat box and in comment section on LinkedIn. So now with all regards, Mr. Donny, I'll hand over it to you. Please proceed.
Thank you very much, Gayatri, and thank you everybody for joining us today. As Gayatri said earlier on, we are hoping today to talk a little bit about some practical issues that arise in enforcement. The audience listening today will be experienced arbitration practitioners who will be very familiar with the 1958 New York Convention. And so today we won't be talking about the well-known bases for recognition and enforcement of arbitral awards. Suffice it to say that you will be familiar with what happens if you take an award to a different jurisdiction and your opposing parties raise legal objections in line with the convention to seek to resist recognition or enforcement. What we're looking at is actually the slightly more practical problem of what happens when your respondent simply doesn't engage, won't pay, claims it doesn't have assets, doesn't talk to you at all. And then what do you do? So we're going to try and explore that with a multidisciplinary approach. As Gayatri said, we're really delighted to be joined by Nick Bortman and Gabe Bluestone, who will give us some perspectives from the investigatory and funding perspectives. To start us off, though, I'll talk a little bit about some interesting legal developments in the enforcement world, with a particular focus on the common law regime. So I'll talk about English law, but as the audience will know, the position is often broadly similar in other jurisdictions, such as the Cayman Islands and the British Virgin Islands, where you might find that your respondents have some or all of their corporate structures. Now, there are important differences between them, which we need to keep an eye out for, but broadly speaking, they will follow many of the tenets of English law. So we'll focus on that in my part of the discussion. Now, why is that relevant to you if you have an arbitration seated in Paris or Mexico City or somewhere else? Well, it's because you might find that, as I'd said, some of the corporate structure touches on one of these jurisdictions. And there are a couple of recent decisions that are potentially quite useful in the enforcement context when you have that fact pattern. But first, we should talk briefly about obtaining a freezing order in support of your arbitration. So if you are at the early stages of your proceeding, dissipate its assets, or getting your final award, you might want to approach the English court for a freezing order, either a domestic freezing order or potentially a worldwide freezing order to preserve those assets. Now, if you have an international arbitration seated in a different jurisdiction, when might the English court take an interest in that? Does the arbitration need to be seated in England, or does the respondent need to be an English company? Well, in short, no and no. If there is some meaningful link with England, in principle, the court could take an interest and grant an injunction. Often, these applications will be based upon the fact that the foreign respondent has some assets in England. But that need not be the case. It will depend on the facts, but if there is any link with England, it may be worth looking more closely at this option. Because the powers of the English court in respect of enforcement support are really quite extensive. Now, one advantage of approaching the English court in this sort of situation is that it can freeze not only the assets in England, but it can also give a worldwide freezing order. If the assets in England are more than sufficient to meet the claim, then we might be talking more about a domestic freezing order only. But if the English assets are insufficient and there is reason to believe that there are assets elsewhere, then in principle, you could go wider. Now, usually you would only get a worldwide freezing order if the English court has some personal jurisdiction over the defendant or if the arbitration is seated in England. But if it's a foreign defendant in foreign proceedings, you would more likely be looking at a domestic freezing order unless there are exceptional circumstances. Now, how does it work in practice? If you secure an order requiring the assets to be preserved, then it would be a contempt of court for the respondent or its directors or its employees. to act contrary to that order, to move assets, etc. And you can also notify third parties of the order so that they will refuse to assist in any improper steps that the respondent might be seeking to take. These might be banks, these might be share depositories, or perhaps a registrar of some relevant assets, like a public registry, so that purchasers will not wish to deal with that respondent and its assets. So you would hope that with a combination of that, you would be able to make it practically very difficult for the respondent to deal with its assets. And if its officers do act in breach of the order, they're effectively committing criminal offences in England and need to weigh up whether they are ready to take that risk. But perhaps even more importantly than all of those factors, the English freezing order typically comes with wide-ranging disclosure obligations. The court will ask the respondent to give an affidavit explaining what assets it holds, where they are, etc. Now, that can be very useful because it can give you valuable leads as you go out and investigate where else you might look to enforce. If you get a worldwide freezing order, you will usually also get an order for disclosure of assets on a worldwide basis. Now, even if your respondent doesn't tell the truth in that affidavit, you have a record that you can use later, so that if you later gather evidence to show that your respondent has lied to the English court, that could be useful to you both in your substantive proceedings, if you are trying to attack the credibility of your opponent in those proceedings that are still running, in your arbitration that's seated somewhere else, let's say, or to assist you in any other enforcement proceedings elsewhere, because you can show the foreign courts that you have a respondent that is prepared to lie in affidavits and to commit perjury. And of course, the fact that all of those pressures exist mean that once you've got your freezing order and your disclosure order, you can seriously increase the pressure on your opponent for settlement. And so the topic I wanted to sort of dive into a little bit further in relation to the recent developments in case law are, well, what happens if your respondent entity itself does not have very much by way of assets, and you need to look a little wider? So what is the possibility of freezing assets, not of the respondent itself, but of third-party entities, against whom you might have no direct claim, but who might have assets against which you may wish to enforce? So, for example, if your respondent holds all of its assets through subsidiaries, you might be able to say to the respondent, well, you mustn't deal with your shares in your subsidiaries, but you might be concerned that those subsidiaries are also under the control of the same wrongdoers. And so you might be concerned about whether those subsidiaries are taking place to strip themselves of their value. Because you might say, well, if I win my arbitration, I'll want to put the respondent into liquidation, and I will want my liquidators to be able to deal with those subsidiaries as valuable businesses, not as stripped shells. So you might have heard English lawyers referring to this as the Chabra jurisdiction. It's a line of authorities in English law that says effectively you can, in appropriate circumstances, seek freezing relief, not just against somebody against whom you have a claim, but you can also seek relief against somebody who has assets that you have a reasonable basis for believing you might enforce against. So it's often discussed in terms of a jurisdiction to preserve assets held by subsidiaries of your defendant, but it can apply to any third party. So you might say there's some other third party that holds some assets, and you have a reason to believe that if you win your arbitration, you'll be able to enforce against those assets, and it's necessary to freeze them. Now, if that third party is a respectable institution, such as a bank or a stockbroker, you might not be able to justify getting a freezing order against it, because you might be able to say, well, it itself is not going to do anything unlawful. If you get your freezing order against a respondent and you serve the relevant third party, you notify them of the order, then they are going to respect it and they're not going to act contrary to it. But if your respondent, company A, has moved, let's say, all of its assets, its money, to an offshore company B that happens to be owned by some of the same people, you might well want to argue that B is effectively just being used as a money box for A. Or even if not going as far as that, you might want to argue that B owes the money to A because it's taken it on loan. And so even though you might not have a direct claim against B, you need the assets there to be preserved. And because the directors are not trustworthy, or the ultimate owners are not trustworthy, you need the court to freeze the assets of B as well. Now, there has been some controversy around the ability to go this far in freezing the assets of someone against whom you don't have a claim. But just last year, an appeal was heard by the Privy Council, the highest court for many common law jurisdictions that's effectively comprised of the senior most judges in England and Wales. And it came from a case in the British Virgin Islands called Broad Idea International and Convoy Collateral, in the context of an underlying claim in Hong Kong against an individual defendant who was said to control a BVI company that had substantial assets. Now, there was a question about whether the BVI courts had the power to grant an injunction against that BVI company in circumstances where, number one, there were no proceedings in the BVI, and number two, there was no claim being pursued against that BVI company at all. Now, the Privy Council clarified that the BVI courts did have power to grant freezing relief in such cases. And so the BVI court, and by extension, the English court and courts following similar principles, have power to grant a freezing order over a company, even if it isn't a defendant, and even if the claim is proceeding elsewhere. But as with all injunctions, the power is a discretionary one, and there will be a number of factors for the court to weigh in deciding whether to grant such relief. But if you have an arguable claim that you have brought or are about to bring, if you can show how you might be in a position to enforce against that company's assets, and if you can show there's a real risk of prejudice if you don't get the freezing order, and assuming you've acted promptly, you're starting from a pretty good position. And then beyond that, of course, it does come down to the individual facts. So that's one development that I just wanted to flag to show the court's sort of reconfirmation of the breadth of this power to freeze assets of third parties. The other development I wanted to discuss is the possibility not just of freezing their assets, where you can show that those assets are somehow linked to your respondent, but actually bringing a damages claim against the third party more broadly. So let's say, for example, you get an award in a different jurisdiction, and you then bring it to England and you get it recognized. So it becomes a judgment of the English court, and your respondent doesn't pay. And let's say you then discover that the respondent's directors or other connected companies have been working to make enforcement more difficult in some way, whether it's moving assets out of its name or whether it's bringing other losses into the company or something else. It used to be the case that you had, if you wanted to bring claims against those directors or those parent companies or those affiliate companies, you had to effectively claim in fraud or conspiracy. And those are difficult claims to be able to bring and prove in many cases, often because it's so hard to get the evidence. Now, that has changed a little bit in that since 2017, English law has recognized tort, known as the Marrick's tort, by which a third party can incur direct liability to the claimant if it is aware of a judgment right against a respondent, and it nonetheless takes steps to make that judgment harder to enforce. And just last year, for the first time, the English court enforced this tort, or it applied this tort, and found a third party liable in a long-running enforcement effort in a case called Lackatamia Shipping and Sue. Effectively, it was a case where the claimant had been pursuing the defendant for a long time and had discovered that the defendant's mother and certain offshore companies affiliated with her had been helping to make the judgment harder to enforce. And so, without having to prove conspiracy or a meeting of minds or any of those other requirements, the judgment creditor was able to bring a tort claim against each of those entities, saying that because they were aware of the judgment and because they were taking these steps knowing that it would make the judgment harder to enforce, each of them had liability to compensate the claimant for its award value. And so that, I would suggest, makes enforcement, the possibility of widening your net for enforcement purposes a little more potent. Now, in all of these discussions so far, I have assumed that you can find the evidence that you need to show what has been going on with the respondents' assets, how they've been moving, what the directors have been up to, etc. But that assumes that we have gathered useful and compelling evidence, and that we have done so in a way that is proper, so that there will be no difficulty in deploying that evidence in court. And as we all know, that is easier said than done. And so to talk a little bit more about the practicalities involved in that part of the puzzle, I'll cede the floor to Nick Boardman. Nick, over to you.
Thanks, Donnie. Yeah, so I mean, you obviously touched on a number of the challenges that one can face in trying to enforce awards against recalcitrant debtors and new options, which is great. But as you say, we need to have the information. You always need to have the information to know how to target those things, and then of course to back up whatever submissions you might make in court. So, I mean, I think to talk about the practicalities from an investigative perspective, rather than talk about them in abstract, I will try to hang them a little bit on a real world example, without naming names and trying to sort of balance discretion with clarity. But it's a common scenario. So this was a matter we worked on a few years ago, and if you can imagine, for the sake of it, 10 years ago, you have an infrastructure developer that is winning tenders across multiple African states. It's well-funded, interesting projects, unlimited possibility, great PR, the usual sort of story. Private JV partners are getting involved. Fast forward a few years, and the picture looks less rosy. Multiple projects have either gone off the rails, failure to deliver, there's been disputes among JV partners, maybe governments have defaulted on their obligations. There's a lot of blame to go around, but in this particular instance, we were instructed by one of the JV partners who had gone to arbitration and had won an award of approximately 20 million US in respect of its claims. And that award was against a local operating company, which is, again, a common feature of these situations where you might have a large global group, but in fact, the contractual counterparty is a local opco, and that can present problems when it comes later to enforcement. So in this instance, of course, the debtor isn't paying, and there's been multiple discussions, but they're not going anywhere. A funder is brought in because the claimant doesn't have the funds to pursue a lengthy enforcement exercise. And at that point, we're engaged. And really, the question to us is very simple. Where are the assets of the OPCO? Does it have any assets? And where are the pressure points that can be brought to bear? And the pressure points are really key in any dispute like this. I think often people tend to focus on this idea that one can identify, seize, and liquidate unencumbered assets of debtors. And yes, that happens, of course, but in many ways, by far the better outcome and less costly, more efficient outcome is a settlement, and sometimes settlement requires pressure. So setting that as the scene, I mean, I think there's a lot of myths around investigations work. and what one can and cannot do as an investigator, regardless of whether it's lawful or not. There's a sort of idea that we have access to some sort of confidential spy database that allows us to just tap in, type in a name, and get all kinds of information that only we have access to. The reality is very different. There's principally three places that we get information from. One is the public domain. Two is witnesses or other interviewees, if we want to call them that, people who, for whatever reason, have firsthand knowledge about a debtor or their operations. And the third, which often in our sector people don't talk about that much, but actually is very important, is discovery. And it's really a kind of amalgamation of legal process and investigations work, but where you bring those two things together. And that's one of the best, when it works, the most sort of powerful mechanisms to obtain otherwise very sensitive confidential information in a lawful way, which of course is the focus here. So just touching on each of those in turn, I mean, the public domain, it can be belittled, but actually it's very rich, and there's an incredible amount of information available. It's often very detailed, it's often unexpected, you need to know where to look, but there is a massive amount of information out there, and it really varies depending on one jurisdiction to the next. The US famously has lots of information available. Saudi Arabia famously has very little. So obviously it's degrees, but nevertheless, you can't overlook it. Now, going back to the kind of example that I started with, the scene, this was looking at the public domain allowed us to map out what was in fact a very complex structure, not just of the operating company, but of its relationship to the wider group. And looking at the public domain, it allowed us essentially to follow the paper trail and build an entire picture, a kind of organogram, if you will, of the entire group's operations. And that's critical to enforcement because it starts giving you a sense of what jurisdictions you might be able to apply to if you're looking outside of the kind of the main operating company's jurisdiction for whatever reason. It also starts to give you a sense of where the pools of value might be, because it's one thing to look at a group of companies, it's quite another to know which of those companies play what role in the organization and which actually have assets that are worth seizing. It also enabled us to essentially gather a long list of potential witnesses. So former employees, former advisors, business partners, journalists who covered the sector. It allows you to form a very long list of potential interviewees, which of course we will then turn to later. And in this instance, it also, the public domain gave us much more of a sense of the history of this particular opco and the underlying asset. And there was some, unsubstantiated allegations of corruption, some links to somebody who was quite a controversial figure in this particular state. And it was just, all of these things come together as a potential, leverage point. So we just have to make a note of all of it. But there are limitations because ultimately the public domain will not tell you very much about cash flows. They won't necessarily, it might indicate where the value is, but often, depending on the country, you're not going to get detailed profit and loss or balance statements for a company, for example. And there was just no, from that, there was really sort of very little indication in this instance that the operating company, which was the debtor, had assets. So of course, immediately we're thinking, okay, well, this is going to be a complex enforcement exercise because simply going against the debtor is not going to achieve what we want to achieve. So at this point, we're really, we start interviewing people, and there's dozens of people to interview, and there, in this instance, there was value in that because the people we were interviewing were telling us how the group operated. They were explaining how money was moved around within the group, which could open up an argument of fraudulent conveyance, which Donnie, you sort of alluded to in terms of, one of the, if you can demonstrate fraud, that may enable you to pierce the corporate veil of the opco. So that was potentially very important. It also, and in this instance, most crucially, identified not just other creditors. So we had a sense of who else we were fighting against in terms of trying to enforce our award. But it also gave us the identity of several debtors to the operating company. In other words, companies that owed the debtor money, which potentially it's itself as a receivable an asset. So in thinking about enforcement, we're not just thinking about a piece of property or a bank account or some sort of infrastructure asset. We might be thinking about money that is owed but not paid to the debtor, and which can be attached by garnishee. And that kind of information really, you might find that in the public domain, or at least you might get a lead because you'll see, who the trading counterparties are. But only really through the interviews were we able to establish with any detail the amount of the kind of quantity in that was owed and by whom, and that gave us still more sort of ideas in terms of how we might use garnishee orders to either bring pressure or to seize a receivable of sufficient value that it would essentially satisfy the award. So at this point, we've got a lot of information, right? We've got everything that we've gathered from the public domain. We've drawn a massive map of this group. We've got all this intelligence about the history of the operation, the people who work there, the counterparties. But what do you do with all this? And as much as we like to think of ourselves as strategists, we're not lawyers. And so we work very closely with people like you, Donnie, and obviously others, to think about, okay, what can we do with all the information that we've gathered? And in this particular case, discovery and the sort of options that the U.S. Legal sort of framework availed of us was key, because we could establish that there was a U.S. nexus to this entire group. And therefore, by establishing that nexus, that enabled us to start an action in the U.S., which then enabled us to get discovery in the U.S. And these are the kind of situations where every country has different tools. In the U.S., you have, if you can get something recognized locally, you've obviously got subpoena powers. You can get information there in aid of foreign proceedings through 1782. In the UK, you've of course got Norwich Pharmacal orders, bankers' trust orders. There's lots of tools like this, and we're always thinking about how to use those tools, because although we get asked a lot about whether it's possible to identify bank accounts or trace money through the financial system, the reality is there's really no legal way that we can do that short of getting legal discovery. We might find a witness who's willing to give us some of that information, but even then there are risks, because we then have to consider, is that witness breaching some sort of confidentiality to their employer? Can we be charged with an inducement of that breach? So we have to be very careful about how we get information, even from a willing witness. And in this instance, what was so kind of powerful wasn't just the discovery itself, but although that might have turned up assets or bank accounts or something that we could directly seize, what it in fact dug up was evidence of an ongoing relationship with this very controversial businessman that I mentioned, who, for whatever reason, we didn't even need to know what the context was or why there was any cash flow going back and forth. The mere fact of being able to show that connection, when we then presented that to the debtor, they instantly said we're going to settle, and they settled within, at that point they settled within I think it was about 6 weeks. So despite all of that work and everything we did and all the possibilities of how we might have achieved enforcement, in fact, it was that one little piece of information that was what really spurred them to action. And so it's a kind of I like this as an example, because it shows all the kind of possibilities, but then often the sort of unexpected path to resolution. So you have to be thinking as broadly and creatively as possible. Now, on the subject of lawfulness, obviously the way as I've laid out, there's various ways to do this that does essentially, give you a path to getting, very detailed, very confidential information that is lawful. But then in terms of, before any of this gets started, there's a kind of basic premise on this, is that you just need to choose who you work with carefully, because despite sort of our focus on doing this a certain way, the reality is there's a lot of investigators in the world, and there's been quite a lot of press on particular ones who I won't name, but who've been well, in fact, admitted to using hacking and all kinds of other tools to get information. And I sometimes equate the kind of investigators approach to these problems as looking at a dinner menu. You've got the appetizers and you got the mains, and then there's dessert, and you can either choose to go to the dessert or not. But it's you have to know that, like, in the context, A, it's illegal, but B, obviously in a setting where you're actually trying to use legal process to force settlement, by engaging in any of that sort of methodology, it can completely backfire and destroy your legal position. So one has to be so careful about how you go about doing this and who you work with. And I guess just to sort of close, I think there's a way in which lawyers, investigators, and funders can really sort of come together, because in the sense that there's a lot of psychology that goes into enforcement, insofar as someone who's trying to avoid enforcement, if they have any sense that the enforcement effort is halting or unserious or underfunded, it'll encourage them to continue fighting, because they see an end to it. They think, if I fight long enough, they'll go away. And so that tenacity is so important. And so for us, we're always thinking about bringing that tenacity in terms of leveraging all the different types of information we have, but of course, having a funder on board, if you need it, that can basically get behind a enforcement effort and make signal to the debtor that this will not stop until the award has been settled. That alone, as a kind of perception, is very powerful. And there's of course lots of funders out there as well, but Omni, we know Omni well. We work with Omni Bridgeway, and they're one of the most aggressive. So it's one of the reasons we enjoy working with them. But maybe, Gabe, on that note, I'll hand over to you to talk a bit more about the mechanics of where you come in and how that works.
Sure. And Nick, thanks for the kind words. And I feel like we're the funder, kind of the third piece of the puzzle here, because this conversation is not dissimilar to a lot of calls I have during the day with Nick and Donnie, or folks in their shoes who are representing a client who is trying to enforce an award or judgment. And often the question is, great, we've got an award, we've gotten a judgment, and what are we going to do next? And this is where the funder will come in. And I think a distinction I want to draw is between sort of what we call enforcement funding, as we've been discussing, and sort of traditional litigation funding, which we call merits funding. So merits funding is your traditional lawsuits, your breach of contracts, your business disputes that have a closed universe, that have a closed record. Once there's an arbitration award, we're entering, or an arbitration award or a final judgment, we're entering sort of what we call enforcement world. And we have now a live ball game that's still playing, where money is moving. As Donnie was referencing, these fact patterns where money goes to offshore entities that are controlled by affiliates of the debtor or relatives of the debtor. And, this is sort of real life and happening right now. It's not the closed record we had in the merits game. So I wanted to sort of make a distinction. At Omni, we sort of separate our enforcement and merits folks. I'm obviously on the enforcement team, and we have about a 40-person team globally. And I've recently joined the U.S. team earlier this year, and there's 3 of us here now, and about 20 in Europe, and a number of folks in Asia. So the traditional matter we look at is the able but unwilling debtor, which sounds kind of obvious, right? We want to pursue the debtor that's got assets but is just unwilling to pay and is going to take some legal arm twisting to either bring them to the table or to execute on those assets. And the process that the funder is going to go through to determine if they're going to fund is sort of essentially whether or not there's sort of a pot of gold at the end of the rainbow, and what's it going to look like, and what are Nick's costs for the investigations going to look like, what are Donnie's fees going to look like. But importantly, we're going to look to multiple jurisdictions. I think at Omni, we look at judgments, the floor we'll look at is 5 million US, and we're going to go to multiple jurisdictions. And I think everyone generally thinks that individuals who have wealth greater than, let's say, 20 million, generally don't keep all their assets in one jurisdiction. So how do we go to multiple jurisdictions? How are we going to be able to be the pebble in the shoe that brings the debtor to the table to resolve it? And in going to multiple jurisdictions, we'll often act as a quarterback in the matter, where we're working with the investigators, we're working with Donnie, whether he's in Canada or England, and we're working with other counsel in other jurisdictions. And one of the ways we fund is where we step in and sort of act as the quarterback globally. We're sort of working with the counsel in multiple jurisdictions, we're working with investigators, and we're obviously covering the entirety of the costs throughout. The second way we'll operate is if the claimant or the lawyer has a comprehensive plan for enforcement. In that case, we're happy to sit back and just fund the matter like we would in a typical merits matter. That's probably less common given the nature of the financial system these days and the nature of high net worth individuals and large corporates, the way they sort of store and hold assets. And the third method, which can be combined with the other two, is a monetization, where we can pay a cash upfront piece for part of the judgments or the entirety of the judgment. So in certain circumstances, we'll buy a complete judgment, take assignment of it, and hold it in an SPV of ours, and then instruct counsel and hire investigators and reap the benefits of the entirety of the award. And a new method we've been looking at, which is common, and I think Donnie and Nick probably run into this situation quite frequently, is you get an award, you get a judgment, and you're not entirely sure of the financial landscape of the debtor. And you say, man, if I only had a few dollars to investigate, take some post-judgment discovery, initiate a third-party action to sort of identify whether there's sort of a there. And this is something we'll call a services and monitoring period, where we'll enter into an agreement with a claimant that gives us a certain period of time where we commit a modest amount of resources to sort of take post-judgment discovery, explore, hire an investigator, typically a 6-month period where we can, in the interim, learn about the debtor's assets, put together a strategy, and then proceed to our investment committee at the end of that period, assuming we've come up with positive information that gives us strong reason to believe that there's a reason for moving forward. And I think that's a popular option because it gives sort of everyone the opportunity to sort of take it step by step. I think Donnie would probably agree that enforcement work is much like peeling an onion, that sort of you got to take it layer by layer because you truly don't know where you're going to be going. And when you bring Nick and his team on, they're going to bring you to jurisdictions that you may not have anticipated when you first got the award. So broadly, we'll fund all fees and costs. That'll cover all the lawyers, any court costs, any court fees. We generally take our success fee as a multiple or a percentage of the outcome. the funding is entirely non-recourse. So if the case is unsuccessful and nothing is recovered, that's it. We take the loss and move on. I will say we generally like to have the interests aligned with the claimant and the counsel where possible, so that everyone has some risk. And we think everyone works better and outcomes turn out the best in those situations. So in closing, I think I'd just like to give a word of suggestion for claimants and counsel who are looking for funding, because I think I look at the internal statistics here and I think we turn down about 95% of matters that are seeking funding. And I think it's quite important when you're presenting to a funder that you succinctly prepare your request. And it doesn't need to be a formal memo, but I think bullet points, one-pagers, and sort of the elevator type pitches that really get the salient facts and the reasons why funding would be appropriate and why the matter will ultimately be successful is really key. I think certain times funders are viewed as sort of unlimited resources that sometimes don't fully dig into the merits, but I think here that's definitely not the case, and we take every investment quite seriously, and the more you can have your ducks in a row when seeking funding, the greater the likelihood that you'll receive what you're looking for and you'll have a good experience in the process. So I think that's it. I think we can, if we were going to turn to some Q&A, Donnie, is that right?
That would be great, thank you. And I know Gayatri is monitoring questions coming in from the audience. But just while we wait for that, I wonder if I might steal a chance just to ask a quick question, Gabe, based on what you were just saying. You talked about sort of the difference between enforcement funding and merits funding upfront. And I imagine that in many merits funding situations, the lawyer applying for funding feels like they are in pole position to talk to you about the risk, to sort of give you a view on the likelihood of success at trial, etc. I just wonder with enforcement funding whether it turns around a little bit, whether actually you guys have got more information about how likely it is going to be to turn a particular enforcement situation into a positive outcome based on your long track record of what's worked and what hasn't.
Yeah, that's a great question. I think it's ultimately a symbiotic relationship where working with investigators in our in-house asset tracing team, we put sort of a framework of a theory we think might make sense, but it's really important to talk to trial counsel to get an actual sense of, what's the sense you get from the debtor? Is there a deposition transcript or trial transcript that can help us either confirm or reject what we think might be happening? I think from both ends, I think there might be moments when the funder arrogantly suggests that the counsel doesn't have a ton of insight because they're not the investigator, doesn't look at it from the angle we do. And I presume trial counsel might say, you're just a funder, you're just an investigator, what do you guys know about this? And I think, folks often look at funders, like they're all the same. And to an extent, yes, we're all providing funding. I think we distinguish ourselves in the fact that we have a dedicated enforcement team that is very hands-on, that has significant experience. But more importantly, these relationships with funders, it's not like the money goes out and you never speak to each other again. I think it's rare that there are not questions or issues that may arise during a merits matter, during an enforcement matter, and I think it's really important who you choose to work with.
Thank you. Gayatri, if there are any questions that you've got coming in, please do feel free to jump in. In the meantime, I might again steal an opportunity just to go back to Nick, if I may. Nick, you had talked earlier about some of the valuable insights you can get just by interviewing people on the ground, whether they are former employees or whether they are other people who've got some link with the target respondent. In practice, how easy is it to actually capture that evidence and make it available in legal process, particularly if the witnesses either are not willing to come forward and testify in any legal proceeding, or maybe worse, they are willing, but actually they're not very good as witnesses?
Yeah, no question, it's challenging. I think from an investigative, with my investigator's hat on, I mean, we're always looking at our interviewees as potential witnesses. So we're always thinking about whether, if someone seems particularly knowledgeable or disposed to be helpful, we always have in the back of our mind a question whether they might be formally brought into the process. The reality is that it's very rare, or relatively rare, that that happens, and for obvious reasons. I mean, the first being that most witnesses have zero incentive to be involved in a legal proceeding, and most people would never choose to be in litigation. And even where we encounter people who, for one reason or another, may feel aggrieved or have a kind of a motive for airing the truth as a whistleblower or otherwise, even in that, if that first conversation or discussion is promising, it's common that after several more, and particularly, unfortunately, meeting the lawyers, they get cold feet. So we tend to think about this as an opportunity to gather information and importantly, to bridge gaps in the public domain, because as rich as the public domain is as a source of evidence and information that you can readily deploy, there are often large gaps connecting, say, a debtor with his or her or its assets, particularly when you come to offshore companies and structures, which, there may be very little by way of direct evidence in the public domain that somebody is a shareholder of, say, a BVI company. And so we just may never even see that company in the public domain. But when we go and talk to people, someone may say, oh, well, they structure their assets, or this deal was, or this company represents, whatever it might be. And armed with that information, it's much easier, or more possible anyway, to reverse it. So if we know or have reliable information that a BVI company is owned by someone, there's ways we can think about how to show that. Whether it's going back to a kind of discovery process, a legal process that one starts in the BVI, or doing a kind of mapping exercise of looking at all the ways that BVI company touches on assets with which the debtor is publicly associated to create a case. So long way of saying it's tricky. I mean, there's been instances in which I have actually given hearsay evidence where I am attesting to information that was given to me by witnesses who did not want to come forward. But as most of the listeners will, I'm sure, know, hearsay evidence is of limited weight, and it works in some scenarios, but not in others. So it's certainly not a get around.
Nick, I've got one question for you, and just sort of trying to think broadly and always facing challenges and forcing judgments and awards. But if there was sort of one database or sort of an improvement you could see that would make your life easier, that's realistic, whether in the US or in other jurisdictions, what would it be? Would it be seeing the UBOs of Delaware entities? Would it be broad access to the Cayman registries? If there's
there's a lot of talk about those UBO registries, which, as far as I'm aware, it's pretty hollow so far. But yes, that would be hugely valuable. Of course, no sooner that the Cayman or anywhere else starts making that available, you can be sure there's going to be a pretty broad flight of owners, structures, or from that jurisdiction, or an attempt then to overlay, rather than have Cayman to shareholder, Cayman to a BVI to a Liechtenstein, whatever. I mean, there's so many ways to get around it. So on the one hand, yes, those would be useful, but you can quickly see how someone might work around it. In some ways, I could point to lots of things, but I think one of the things that I would find very useful is if there was a better consolidated litigation record, not just, including in countries that are obvious. I mean, like the US. I mean, of course, you've got databases like PACER and others for federal proceedings, but there's often good information locally at the county level or the state level, and it can be, it's a lot of work that goes into to identifying those proceedings, and that's the US, which has an arguably favorable kind of public record regime. Most countries in the world are far from it. So, and yet, it's amazing what you can learn from litigation records in terms of looking at another dispute, and either you're identifying past form, or you're looking at how someone has already sort of evidenced, say, fraudulent conveyance, or you're getting detailed records of assets or something that shows relationships. I mean, often there's so much confidential information, otherwise confidential information, that gets filed in litigation and arbitration, that I would love to have a more consistent access to that material. And the reality is, often where we're enforcing against a debtor, we're often not the only ones. There'll be other litigation, other litigators, there'll be other proceedings that if one had access to, could be very interesting.
And Donnie, maybe a question for you. If there was sort of a procedural change that you could add either in the Canadian courts or the English courts that might help you in your enforcement matters, whether it's more US style post-judgment discovery, is there a fix that you would like to see or would suggest?
I think that in a way the tools are broadly there. It's more a question, I guess, of how willing the courts are to deploy them. I'd say one challenge quite often is if you have got a really good, strong basis for seeking a freezing injunction against an opponent at the early stage of your proceedings, and you're trying to secure your eventual enforcement, you might be able to persuade the court to give you a freezing injunction, but in return, you've got to give a cross undertaking in damages. So you've got to promise that if it turns out that either your substantive claim fails or the freezing order should never have been given, and the opponent has suffered damage, that you will pay the damages. And what's more, you usually have to fortify that cross undertaking with some sort of assets. Now, if you are a claimant that suffered tremendous loss because of the wrongdoing of a respondent, and you just don't have the assets to be able to fortify, it can tie one hand behind your back. And I think one question that probably does need exploring further is, in principle, it is open to the court to say, well, we don't need a fortification in this particular case. But the question is, in practice, should they be more willing to look at situations where they say, well, in order to grant the injunction, I don't go too far into the merits of the underlying claim, but actually in deciding whether or not I should put somebody to fortification, I should look at how credible their merits claim is. I should look at how credible the risk of dissipation is, and I should ask myself whether it's really likely that the respondent is going to suffer any damage here from this freezing injunction before I simply ask a claimant, well, if you want to freeze $20 million of assets, you need to put up some millions by way of fortification. I think the court's greater pragmatism, in practice there would be really helpful.
Gabe, I wonder if I can ask you just a real quick question. I know we only got a minute or so left here, but just of the moment, the crypto collapses. Are you guys getting approached already by any potential claimants who need funding to chase some of that down, or are you even willing to take on cases yet where enforcement against crypto assets could be a major part of it?
In short, yes, inquiries coming in. I think we have sort of an internal expert, a colleague, and I think we're still wrapping our heads around sort of A, what the end of the road might look like, and B, how exactly we get there. So I think we're taking sort of a cautious approach, but I think, we are open to exploring it and are actively exploring.
I think we're going to have to, whether we're open to it or not.
Yeah.
We have one question asked by the audience. Under what circumstances may an award be retracted or revised for fraud and other reasons? So if anyone wants to answer that on the panel.
I can say something very quickly about that. There is effectively, at least in English law, there's a string of authorities, actually, I think originally coming from a Hong Kong case. Effectively, if you can show, but it's very rare that you will find that the actual decision maker was corrupted, right? That the judge or arbitrator was corrupted in some way. What is more likely is if you can show that the proceedings were somehow infected with fraud. Now, it's not usually going to be good enough just to say, well, after the fact, I can prove that one of my opponent's witnesses lied about something. You've got to show something material that actually goes to the decision making. So if you can show that some evidence was fabricated, and that evidence was the crucial thing that turned the decision against you, then you may be in a position to effectively seek a set aside and then a rehearing in some way. But overall, it is not a low threshold. It's deliberately set relatively high because the broad position is, of course, people need finality and need to be able to get on. I hope that answers the question.
Definitely, I feel so. And there's one more question asked by our audience on Zoom. Why is ADR considered secondary and not the primary process of conflict resolution?
So is that ADR? Oh, you're muted.
Am I audible?
Yeah.
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 So there's one more question from our audience on Zoom, that why is ADR considered secondary and not the primary process of conflict resolution?
I certainly wouldn't. I mean, weirdly, in the UK, they have now renamed ADR as NDR. So it's now called negotiated dispute resolution, because the view is that it should no longer be alternative. And I certainly wouldn't say that it's sort of secondary in the sense that every case I work on, there is a litigation track and a settlement track in parallel. And that's always an important part of it, because you need that dialogue for people to constantly ask themselves whether they can price the risk of the litigation without needing an external decision maker. So I would have thought that, it can run in parallel, but the truth is people will only take negotiations seriously if they can see that there is the backstop, that if they don't engage properly, there might be a judgment or an award against them. It's the sort of, it's what's inside the velvet glove that counts as well. And on that note, I don't know, Gabe, whether you have a view, but certainly my sense is that in many other situations, funders are interested not only in what the legal track looks like, but they're also, when assessing the merits of an investment proposition, they're also looking at how plausible the settlement track looks.
I think that's entirely right. I think funders appreciate certainty where possible, and trials and coin toss outcomes are not what we desire. And so where we think an ADR or a mediation can get us to a resolution, or we see a path to that, I think that's favorable in our views for sure.
Thank you, Mr. Dhoni, for addressing this very important question. And I think we have reached the end of the session. And now I would like to conclude by thanking all our panel speakers for sharing their valuable insights on the topic. And we definitely look forward to more such interactive sessions and engagements in near future. And thanks to our lovely audience who took the time out to join this wonderful conference on a very important topic. And just an update that the recording of this conference is always accessible on our World Law Alliance LinkedIn page and the YouTube channel. So you can always check that out on these platforms. And I'm also glad to announce that we are coming up with International Arbitration and Mediation Conference, WLA 2023 Dubai next year in April. So the registrations are still ongoing, and you can always write to us at contact@worldlawalliance.com. So thank you everyone for taking the time to join in. And before I end this conference, I would like to have some closing remarks from our esteemed panel who joined us here today. Starting with Mr. Donny.
Only just to say thank you, Gayatri, for having us, and thanks to Nick and Gabe for joining me. It's been really insightful, and I look forward to continuing the conversation.
Thank you so much. Mr. Nicole.
Just delighted to have been here. I really appreciate it.
Thank you so much. It's our
Yeah.
pleasure.
Thank you, Gayatri, and thank you, Donnie and Nick. This was fun, and thanks to the attendees for participating. And hopefully we provided some information and maybe of some help going forward.
Thank you. Thank you, everyone. And with this, we end today's topic of discussion. Thank you all. Thanks.
Thank you, Gayatri.
Thanks.